In this video, I'm going to talk personal guarantees. And what I'm going to do is I'm going to go through what a personal guarantee is officially, but also unofficially. I'm then going to sit there and tell you advice and give you information that you won't necessarily be told and is quite difficult to come by, the stuff that you probably want to be knowing. And then lastly, I'm going to give you a real life case study of what happens when a personal guarantee goes wrong. If you want to know everything you need to know about personal guarantees, stay watching to the end because you're going to get advice on this video that you're probably not going to get elsewhere. Welcome to Cut the BS Business, the business channel that will give you real life advice but cut all the BS out of it. If you want a business channel that's going to give you real advice that you're probably not going to hear elsewhere and from someone who's been there, done it, got the t-shirt, then this is the channel for you. If you like what you hear, do consider subscribing to the channel, and if you do, click the bell icon so you won't miss any one of our videos, and if you like this video, give us a thumbs up. So what is a personal guarantee officially? So if we start there and then move on to the unofficial part of it, a personal guarantee is basically a counterpart legal document that you will sign when you're taking out a finance or a loan agreement of some kind and you're a business owner or you're a director of a business. So the way this works is that by signing this document, you are saying that if the company fails to pay that debt or they miss a payment on that debt, then that director who has signed it is then personally liable for covering that debt. Unofficially though, this is the problem. A personal guarantee is signed mostly by companies that are private limited companies. So a private limited company in the UK, you'll know what this means, but you've basically got a gap between the liabilities of the business and the personal liabilities of the directors of that business. So i.e. if the business went under, creditors and everything, they can't start chasing down the directors of the business. It's nothing to do with them. It has to come from business assets. So you're safe and secure and separate. And that's the beauty of a private limited company. However, by signing a personal guarantee unofficially, you break that link. You bridge the gap. You are therefore liable for the debt. Okay. Now, this isn't all of the debt to the business. This is just the debt that that personal guarantee relates to. Unofficially, that is effectively a bridge to your personal finances if you're a director and you sign a personal guarantee. So let's go through advice that you're probably not going to hear elsewhere. Now, first of all, I do need to sit there and explain I am not, to cover myself, a legal professional. I am not a solicitor. I cannot give you legal advice. The information I'm about to give you is purely from an opinion and personal experience perspective. You can do with this information as you wish, but to clarify, I'm not a legal advisor. I cannot give you legal advice. You are recommended to go and seek independent legal advice. Let's go through the advice part of it, and I'll go through it firstly as if you're considering signing a personal guarantee, and then I'll go through it if you signed the personal guarantee and then all of a sudden things went south, what happens and what advice could I give in those instances. If you're in a position where you're considering signing a personal guarantee, what you're going to be expecting is a lender is going to say, we're going to give you money, but you need to sign a personal guarantee against it. We're regulated by the Financial Conduct Authority, and they'll be very rigid in the way that they will explain this information. They have to do it. It's a highly, highly regulated sector, the financial sector. So they will explain the facts, but the personal experience I got, it's as if they portray it as, well, everyone gets a personal guarantee these days. It's completely normal. Don't worry about it. You'll be fine. That's kind of my personal experience of, without them saying that directly, that's very much the feeling that you kind of get from these people. This can be from a bank, it can be from an independent financial business, and it tends to be where it'll be against a loan, it will be against an overdraft, and it seems as if after COVID, any sizable amount of money, they just want a personal guarantee. And if you go and sign one of these personal guarantees, they will advise you that we can go after your personal assets. And this basically means your house, your car, any money in your bank, stocks and shares, your pension, the lot, everything. Everything's on the table if you default on a personal guarantee, and that's the risk with it. Now, they won't necessarily word it as detailed, as blunt as that, because they want to sell you a product. Their interest is in getting your money. So you've got to bear in mind that they will recommend you seek legal advice on this, okay? So what's the legal advice you could get? Well, really, you've got two routes for getting legal advice about personal guarantees. One of them is a solicitor, which they will recommend you do. They should do anyway. They will just word it as independent legal advice, but basically mean go to a solicitor. And the other is going to an independent kind of business advisory kind of service. And I'll go through that part in a moment, all right? But the solicitor part, just from personal experience, how did I find it? So what this is you'll contact your solicitor and say, I'm considering signing a personal guarantee. I want advice on it. What's the score? And they will go, come in with all your documents relating to it, the contract itself, the personal guarantee document, and any other supporting documents that's involved with this. And what they'll do is they'll bring you in, you'll pay them money, and they'll sit down and read through the document. They'll then clarify what the bullet points are, which, if I'm in the nicest way, I personally could just ask my nan, and she would tell me that, because it says it on black and white paper. And then they will then go, have you got any questions? And I'll ask them, what does this mean? It means that. Okay, so what happens if this circumstance happened? I can't give you advice on that. Okay, so what should I do if this happened? I can't give you advice on that. I can only read the facts. Because their information they give you is very finite. They just stick to the facts. They don't give you any real advice. You don't get anything from it. They just explain what it means. So my personal experience of it was money down the drain. It wasn't that expensive, but it was a bit of a waste of time. But that's my personal experience of it. You would be recommended to seek your own legal advice, as I'm not a legal professional. Or the other group of people that do this, and there is some useful advice here, would be companies that are helpful. They're trying basically to get directors of businesses who need help or need support, who need advice, to go to them, to pay them to give them that advice. And they're basically like financial rescue businesses and things like that for directors of businesses that are struggling, that might find themselves in a position where they're thinking, right, I might not be able to pay my personal guarantee. What happens here? And some of that advice is good, but all I would say from my opinion with that is it's very much, we want something from you, so we're not really going to give you the full scope of it, because otherwise you won't pay for our services. So a bit of the advice that you probably need to know about personal guarantees when you go and sign them. If you sign the personal guarantee itself, they're hunky-dory with you as long as you pay your bill. If you pay your bill every month, you will never hear from them. That's all they care about. It is a money-making exercise, and ultimately with a personal guarantee, it is investment, because it's going to be a finance agreement. It could be an overdraft with your bank, and they're going to make money if you go into the overdraft through interest. But if you don't pay or you miss a payment, what happens then? So let's talk case study, okay? And we're going to do a case study with a guy called Bob, let's say, all right? Bob's got a business. Bob signed a personal guarantee where he took out, let's say, £150,000 for his business, and with interest, it's 180 grand, and he's got a 5-year deal on that. Bob was in a position where he had won a contract with a customer, and he needed to buy 150 grand worth of equipment to be able to fulfill the contract for that customer. But 2 years in, he gets a nasty call from the company that he's got the contract with, who say, unfortunately, Bob, sorry mate, we're going out of business, we've got no money in the bank, and we can't make the next payment. Unfortunately, that's it, bust, sorry to bring a bad news. What situation is Bob in then? So the first thing that Bob should be, Bob done, was that he's going to look at his finances, and he's going to go through them. Basically, through other contracts or other means, does Bob have enough money to keep his business going? Is he going to be able to keep paying up payments to creditors that he owns, or is he going to be in trouble? And let's say that he does the maths and he looks at it and goes, can't afford to pay this. We're in trouble. What are my options? What do I do? I can't afford to pay these bills. Well, in that instance, you've got a couple of things that Bob can do. Bob can either bury his head in the sand, which is a problem. Now, burying your head in the sand is a bad idea. Basically, the reason for this, if you bury your head in the sand as a business owner, as soon as you realise your business is going to go under, what will happen if you play it down the line is an insolvency practitioner, who is the person who is responsible for winding up a business. They will sit there and investigate the conduct of directors in the run-up to that business going under. And if it is seen where a director has not looked after the best interests of creditors, they're going to be seen as not have obligated their director's duties. Now, let's say Bob's in this position where he realises the business has gone under, and he doesn't want to go down the route of doing anything wrong. He wants to be seen as reasonable and fair and doing the right thing. He'll go to take legal advice. And there are two routes you can take legal advice from, but they both do the same thing. One of them is an insolvency practitioner, which are typically a business that is bolted onto an accountancy firm, and the other is an independent kind of director kind of help business, okay, where they will give you support as a director and then also give you advice and basically manage the administration of the business. But both those companies will do both. And it's a bit of a conflict of interest, because what they do is, up until the point the business is put into administration, they will be giving you advice and help and support for you as a director, because they'll try to sit there and go through your options of what they can do. And often these are other products or services that they offer that can make money out of it, but they're probably going to benefit the both of you. As soon as you pick them to be your administrator, and that's basically where they will make their other part of the money, because if you've said, I want you to be the administrator, then any money that's collected from that business, first of all, they get a fee from. They get paid before anybody else when that business goes into administration, because they need to cover their costs and then to make a little bit of money out of it because they're a business. But as soon as they become your administrator and they put the company into it, you are no longer the director and they represent the creditors, and then all of a sudden it feels like they're stabbing you in the back. They are legally obliged to do this though. This is the weird thing about UK law and the way it works, but this is how it operates. And insolvency, it's a bit strange. When you go into administration, the first thing they will then do is they will then notify all of the creditors. They will then, in that initial document you've given them, all the contact, how much you owe, who you owe it to, and they'll contact all the creditors in the business, and they'll act on your behalf and start doing all the phone calls. As soon as the one that knows that you have a personal guarantee with gets that phone call, the first thing they're doing is sending you a letter that you'll receive within 14 days that is basically a demand for payment. And they will say, you have 28 days to come back to us with a payment proposal of how you are going to repay this money. Now, even though the business itself might have enough money to be able to pay the majority or all of this money off, as soon as the company gets put into administration, they'll be straight onto the director to get that money. So either they get it from the business or they get it from you, but it doesn't matter. They're coming straight after you, because you, by signing that personal guarantee, you've kind of signed your life away a bit. That's what Bob's done. So Bob's now in this position where he gets this letter, and it's a very threatening letter. It will say you've got 28 days to submit payment proposals. We also demand you fill out this statement of means, which you will also get from an insolvency practitioner, and they'll ask you for that as well, which is basically you listing all your assets, all your money, everything you've got, and you're legally basically saying this is truthful and honest. I'm not making it up. And if it's found to be dishonest, you could be in all sorts of problems. Now, Bob has got two options. Bob can either respond to them or he can ignore them, okay? So if he responds to them, he then goes down the route of something that your insolvency practitioner may or may not go through in detail with you early on. A good one will do, okay, which is the realms of what's called preference payments. Basically, what a preference payment is if you are seen to have paid one creditor before or treated one creditor with preferential treatment over another, that puts you then into the area of preference payments. That will get you a director's ban, a hefty fine, and a lot of trouble. And Bob's either got the money to be able to pay them from the business, he's got not enough money to pay them, or he can pay some of it. And Bob's therefore got to balance what his financial situation is regarding how he wants to play this one. So if, first of all, the business has enough money in it to be able to pay in line of preference creditors right down to what's needed to be able to pay off this personal guarantee payment, Bob might not have to worry about paying anything out of his own pocket, because it's only the money that's on that personal guarantee that he has to worry about. So, with the way that creditors work when a company gets wound up, the first person to get paid is the insolvency practitioner, followed by, in order of the actual creditor ranking, the ones with a debenture, also known as a charge, which is basically companies which will file with Companies House that they will get paid first if the business goes under any money that they are owed. Secondly is your secured creditors, which are the ones which are going to include the one with a personal guarantee. And after that will be unsecured creditors, directors' loan, and other third parties. If within the business there is enough money in terms of cash that the business has got to be able to pay your debenture creditors off, the insolvency practitioner's fees, and your personal guarantee fee, I wouldn't say don't worry, but that can come out of that. But you're probably best not to start engaging with them to say, I'm going to pay you. If Bob goes back and starts engaging with them, he's got to then make sure that he engages with every creditor so he avoids preference treatment. So he needs to know what he can afford and what he can't afford. He's going to work out that it's going to cost money for the company that he has the personal guarantee with to make him bankrupt, and then to be able to go and pay the legal fees to recover the assets to get the money back that they need. Now, if Bob doesn't have enough money to pay it all off from Bob's assets, then that company can only recover a certain amount of money. What their decision and preference is going to be on is if they're going to recover more money from making Bob bankrupt, then they'll go that route. If they're going to recover more money from Bob's payment proposal, then they'll go that route. Bob needs to know what one's going to be a better option. And if he's going to put a payment proposal together, he's going to put a payment proposal together which is favourable over the cost of what it would be to if they made him bankrupt. And making him bankrupt could cost a few grand, legal fees, all sorts of stuff, time consuming, everything. So they may well be very amicable to a nice deal. But let's say, worst case, Bob is in a position where he can't pay any of this and he's got nowhere near enough money, and even insolvency practitioners said you need to prepare yourself for bankruptcy. Bob's probably better off not bothering engaging with anyone. Because if Bob's in the position where Bob doesn't and Bob didn't engage with anybody, what actually happens is after 28 days, we'll just send you a few more letters. And until the business is wound up, nothing will happen. After that point, they may well make Bob bankrupt. Bob can pay 600 odd quid to make himself bankrupt. But as long as Bob hasn't done anything wrong in terms of his director duties, then and made any preference payments or treated anyone unfairly, anything like that, then Bob will be made bankrupt and he cannot be a director for 1 year. Then after that, he can carry on and get on with his life. So that's Bob's kind of case study. If you have any questions, you want to know anything on it, and you want to give it from Bob's advice, obviously, not legal advice, put them in the comments below. If you want to see any other videos, do put them in the comments below, and we'll see you for the next one.